So to begin with, today we are going to be dealing with few of the most important topics that are, sought after by the University of Mumbai. And, this session has been created in a very exam-oriented way. So I have taken a few important questions in this session that would be helpful for all of you. So to begin with, our first topic for the day is what are memorandum and articles of association, right? So I'm sure many of you already must be aware of, these essential documents that the company has to prepare, right? So these are also known as the constitution documents, which are extremely essential since the inception of the company, right? So a memorandum of association is essentially a legal document which describes the purpose of the company, right? And it identifies the scope and the powers of the company beyond which the company cannot go. Okay. So while incorporating a company, the first step towards incorporating a company is preparing the memorandum of association, right? So we'll also delve into the definitions as per the Companies Act. So Section 2, Clause 56 of the Act defines memorandum to mean a memorandum of association of a company as originally framed and altered from time to time in pursuance of previous company law or this act. This essentially means that the previous Companies Act as well as this Companies Act, so the memorandums of associations, those were prepared previously before 2013, as well as the ones that were made after, right, are included within the scope of this definition. Then Section 4 of the Act specifically talks about memorandum of the company and its contents. Okay, so we are going to be studying the contents of the memorandum of a company as well. Now, broadly speaking, the contents of the memorandum of association contain the objects of the company. As we've discussed earlier, it essentially outlines the scope of the company, the entire company, right? Beyond which a company cannot act. So the objects of the company, which it shall pursue within its lifetime, right? That is one. Second is that it determines the scope of operations beyond which it essentially cannot act, right? And it also enables shareholders, creditors, and all those businesses that are also associated with the company, right, to understand the basically to understand the scope of the operations of the company. Okay, so these three are the broader contents which essentially say the same thing, that the scope of the company, right, beyond which the company cannot go, and it is essentially for the third party, right? That is the shareholders, creditors, and all those businesses who have terms with the company to know what the powers and what is the range of the company's activity essentially. Now, this is the question for you. Based on what we have just discussed, what do you think? Is the memorandum of association a public document or a private document?
Public document.
Correct. So, memorandum of association is a public document. It is available for the public for its inspection, basically. So they have to make a request with the ROC to view the memorandum of association of any company. Now, the forms of the memorandum of association are prescribed in Schedule 1. Now, because there are different types of companies, right, the forms of the memorandum of association will also change, correct? So these are mentioned in Schedule 1 of the Act. So Schedule 1 essentially has the formats for these memorandum of associations. So if you are essentially preparing, say, for example, a memorandum of association of a private company, private limited company, right? So you will refer to that particular schedule and you will prepare your memorandum of association based on that. Now, the memorandum of association essentially consists of the following clauses. Now, these are all very general, but we'll still be discussing them in detail in the next slides. So the first is the name clause. the registered office clause, the object clause, liability clause, capital clause, and the subscription clause. So the name clause, right? It is actually quite self-explanatory. A name clause essentially talks about the name of the company, right? So, for example, if it is a private company, we all have seen boards and we all have seen companies ending with the suffix private limited, right? So those companies are private companies, whereas public companies essentially end with the suffix limited, right? So all this is quite general. So it is easier for us to remember while writing our papers as well. So in name clause, we only have to mention what essentially can be the name of the company. So this is something that is defined in the Memorandum of Association. Now, similarly for International Financial Service Company, that is the IFSC company, whether it is a public company or a private company, right? IFSC or International Financial Service Company shall be in the suffix part of its name. It is very similar to the private limited and the limited company. But there has to be some restriction, right? The name essentially cannot be identical to someone else's name just because, say, for example, there is a company called Amber Agro Limited, right? You cannot have another company called as Amber Private Limited because the names are very identical, right? So the ROC itself will not approve of that. So the names cannot be identical is the first restriction. The second is that if the name is undesirable to the central government, if it is not very, what do you say, if it is not decent enough, or if the central government has any objection towards it, that name cannot be used for your company. Okay, there are certain exceptions to these rules as well. Now, from the above, we understand that each type of company will have a suffix, right? Either it will be a public company and it will have a limited as its suffix, or an IFSC company, right? But there are certain exceptions to this rule as well. Now, Section 8 companies, right, which are generally for non-profit organizations, right? They do not have this particular rule. So their names need not end with the suffixes that were discussed above, right? Similarly, few government entities also need not end with these suffixes, right? So these exceptions and then the basic rule. This can be covered in the name clause of the Memorandum of Association. Now, the second clause is the registered office clause. Now, registered office clause, as you know, it's quite self-explanatory. It essentially provides the registered office address of the company, right? It is also called as the situation clause because it essentially states where the office is situated, right? So that is the second point. The third is that it also helps. Now, see, because the registrar of companies are also located in different states, and you know, this address, the registered office address, will essentially determine the jurisdiction of the registrar of companies. This will help the company in making the requisite filings with the appropriate authority. That is why the registered office clause is also extremely important. If there is any change in the registered office, it is also required to be promptly communicated to the ROC within 30 days from the date of incorporation. Okay, date of incorporation or the date of change. Okay. Moving on, then we have the object clause. Now, the object clause of the MOA is one of the most important clauses because, as we discussed, a memorandum of association essentially outlines the scope of operations of the company beyond which it cannot act, right? So the object clause essentially defines the objects of the company. Okay, so under section 4, 1C of the Act, the company must state in the Memorandum of Association the object for which the company is proposed to be incorporated, right? So it essentially talks about the objects for which the company is incorporated or proposed to be incorporated. The purpose of the object clause is to enable persons dealing with the company to know its permitted range. Like, for example, the shareholders, the creditors, okay, any third parties, any other businesses that deal with your company, because this is a public document. They will have access to your MOA, and they will essentially use this document to understand what the company does. Okay. Now, as discussed previously, the acts that are beyond the ambit of this object clause, if the company does anything that does not fall within the purview of this object clause, then that would be construed as ultra vires and void. We will be discussing this in the next slides, but essentially anything that is not defined in the object clause, if the company acts beyond that, those acts will be void and they cannot be ratified by the shareholders as well. Moving on to the next clause, the liability clause. Now, the liability clause essentially talks about the liability of the members. Now, we know that company is a separate entity, right? But it is run, or it is essentially held by the members of the company, right? Members or the shareholders. Okay. So now, in case of an unlimited company, the liability of the members is definitely going to be unlimited. It is not going to have any restrictions, right? So in case of a limited company, right, a company that is going to be limited by shares, the liability of the members is restricted. Restricted till what extent? Now, in case the shares are fully paid, their liability is limited, right? Now they do not have any further liability. But if their shares are unpaid, right, if they are partly paid shares, then in that case their liability is restricted only to the amount of unpaid shares. Okay, so that is an unlimited company and a limited liability company. Now, for a company that is limited by guarantee, the liability of the members is restricted to the amount each member has agreed to contribute at the time of incorporation. Now, this is slightly different than the company that is limited by shares. There is a very small difference because it essentially says the same thing, right? But in case of guarantee, right, it is not necessary that the shareholders and the guarantors are the same persons, right? It may also so happen that that in case of a liability, a limited liability company, okay, the shares may be fully paid, okay, but they may also further guarantee some amount at the time of incorporation, okay, making their liability a bit wider than what a liability would be in case of a limited liability company, which is limited by shares. Okay, so that is a very thin line of difference between these two. Then section 4, okay, subsection 1D of the act states that the liability of the member of the company is to is specifically to be mentioned in the memorandum of association, right? So every memorandum of association has to specify the liability of its members. Okay, it can be limited or unlimited, as the case may be. Moving on to the next clause, the capital clause. This is also quite self-explanatory. It essentially talks about the capital of the company. Now, in India, there is a concept called as an authorized capital, right? Or the nominal capital of a company. Now, beyond this, a company cannot issue shares. Okay. So in case, say for example, the authorized share capital of a company is 10 lakh rupees. Okay. And the face value of shares is 10 rupees each. So beyond 1 lakh shares, the company cannot issue any additional shares unless and until the constitution documents, the articles of association, are changed to that effect. Okay. For additional issuance of shares is what I'm saying. Now, the capital clause will essentially outline this, the authorized or the nominal capital of the company. Okay. This amount essentially lays down the maximum amount, right, beyond which a company cannot issue. And you have to alter the memorandum as per section 61 of the Act. Okay. So section 61 essentially provides the method in which you can make this change. Now, if both equity and preference shares are there, right, in a company. Now, equity shares are the common shares, right? And preference shares are the shares with a preferential voting rights. So essentially, voting rights are different for preference shares. So these are essentially issued to investors, that come in at a later stage of the business. So if both these are there, then the division of capital has to be under two separate heads. You cannot say that, if 1 lakh shares are the authorized share capital, okay, and say 50,000 are equity and 50,000 are preference shares, then both of them have to be separately mentioned. They cannot be clubbed into one, okay. And the last point is that the company is not authorized to issue capital beyond its authorized nominal or registered unless the requisite changes are made to the constitution documents of the company. Okay, so this is the capital clause. Moving on to the subscription clause. Now, subscription clause is quite similar to the capital clause. It can be said that it is an extension of the capital clause because it essentially talks about the initial subscribers to the company. Okay, so it defines the initial subscribers at the time of incorporation of a company. Now, each subscriber has to state the number of shares he or she is subscribing to. Okay, so the number of shares that a shareholder, basically a subscriber, can hold cannot be less than 1. So each subscriber to the memorandum has to have at least 1 share. Okay, and there have to be 2 witnesses to that particular thing at the time of signing of this memorandum. Okay, so these are the requisites. Other than that, what will happen if it is a 1-person company, right? A 1-person company essentially has only 1 subscriber, right? So in that case, if you're preparing a memorandum of association of a 1-person company or an OPC, at that point of time, you also have to nominate another person, okay, who will become a member of the company in case something happens to the initial subscriber. Okay, so that is a nominee clause that is also included in the subscription clause of the memorandum of association. Now, moving on to the articles of association. Okay, now memorandum of association is a public document, whereas articles of association is a private document. Okay, both these are constitution documents. They are prepared at the time of incorporation of a company itself. They are very important for a company, but there are a few differences which we are going to be talking about now. Now, a memorandum of association essentially talks about why, the purpose why the company has been incorporated, the scope beyond which a company cannot go, right? But the articles of association tell us how. Okay, how can a company undertake certain acts? It essentially can be construed as bylaws or rules and regulations that govern the internal management of the company. Now, the AOA lays out tasks, right? It essentially lays out how tasks are to be accomplished. Okay, now we'll also look at the definitions. Now, according to Section 2(5) of the Companies Act, similar to the Memorandum of Association, okay, the definition is quite general. Okay, articles mean the articles of association of a company as originally framed or altered from time to time or applied in pursuance of any previous company law or this act. Okay, similarly, any articles of association that was prepared before this act was enacted, like before 2013, will also be construed as articles under this provision. Okay, articles of association are also includes regulations that are contained in table A of the schedule, right? They also apply to the particular company. So the forms, as we discussed, the memorandum of association, the forms of memorandum of association are provided in the schedule 1. Similarly, articles of association, there are certain regulations that are also contained in table A, which are required to be followed while proceeding with preparation of articles of association. Now, after that, Section 5 of the Act also talks about articles of a company. Okay, it talks about articles of a company. That is, it shall contain regulations for the management of the company. That is similar to what we have discussed. It essentially talks about how to get certain acts done. Okay, so contents of the articles of association. Now, even though in this slide, right, we had in detail discussed about what each clause of a memorandum of association is and how, what are the important points which are required to be covered. In this slide, we think that, the contents of the articles of association are shorter, but it is to the contrary, right? These are just the points that are, at the top of my head, or, that we can actually write in the exam. When you go into the nitty-gritties or in the practical aspects of things, an article of association is a much more detailed document, because it essentially defines, or it lays out the rules and regulations in which each action is transacted in a company. Okay, so these are just a broad overview of the actions or the points that are to be included in the articles of association. Now, articles of association usually specifies the way in which the company will issue securities. Okay, so in case of issuance or additional issuance of shares, right, what is the proper method that is going to be mentioned in the articles of association? It distributes dividends. Okay, dividend distributions in case of a company, how are those to be governed? That is mentioned. Okay, performance of financial records. Okay, basically how are financial records to be maintained, right? All these things are governed through the articles of association. Now, general meetings, how to conduct general meetings. Okay, appointment and remuneration of managerial persons, adoption of preliminary contracts, everything. So any act that you think a company can undertake in its lifetime has to be covered in the articles of association. The how has to be covered in the articles of association. Okay, now section 14 of the Companies Act, it essentially states how you can alter the articles of association. Okay, so it can be either by adoption of new set of articles. Okay, you can actually replace the existing articles and adopt a new set of articles with new governance mechanisms. That is one way. You can either alter the existing articles. That can also be done. So this has to be done by passing a special resolution in an annual general meeting. Okay, and every alteration to the AOA has to be communicated with the registrar of companies within 15 days. Now, previously, the timeline for this was 30 days, which has been changed to 15 days. So every time we appear for a paper, right, it is very important for us to be thorough with the BEAR Act, with the latest version of the BEAR Act, because there are a few changes that come in, you know, here and there. So we have to be very careful about that. So this is how, these are the method, like these are the ways in which you can essentially alter the articles of association. Now, this is a question for you guys. What will happen if there is a conflict between a memorandum of association and an article of association of a company? Can anyone answer this? Okay. So from what we've discussed, right, we already know that a memorandum of association is a public document, right? It essentially defines the purpose of the company, right? Now, what if the articles of the company, they go beyond what is mentioned in the MOA? Obviously, the articles of association will not stand on its own, right? It has to be in consonance with the memorandum of association. If there is a conflict between the MOA and the AOA, the MOA is going to prevail, right? So this was the brief about the memorandum of association, the articles of association of the company. We'll quickly skim through the differences between the two in order to ensure, better understanding. Now, the first difference that we've, already discussed is that it is memorandum of association is a public document, articles of association is the private document, right? A memorandum of association essentially talks about the how, right? The scope, it talks about the scope, but the article of association talks about how to do the act, right? So the clause of memorandum cannot be easily altered because it is a public document. That is also very clear from what we've discussed. A public document, in order to alter a public document, there are more stringent compliance requirements, not only internal compliance requirements, but also external, right? So you have to ensure that you are, making the requisite filings in case you're amending the memorandum of association. Now, in case of articles of association, the members have a right to alter the articles by a special resolution. Generally, there is no need to obtain, a court or a central government permission to do so, right? Now, a memorandum of association cannot include a clause contrary to the provisions of the Companies Act. This is also very clear. So anything that is contrary to the Companies Act in the memorandum of association will be outright void. It cannot stand. It cannot be ratified by a majority of shareholders. Nothing can be done. It has to be in compliance with the Companies Act. In case of articles of association, it not only has to be in compliance with the Companies Act, but it also has to be in compliance with the memorandum of association. Okay. Then, so these were the broad, points of distinction between the memorandum of association and the articles of association. Now, in case of articles of association, if any act is undertaken by the company, okay, articles of association may, if any act is undertaken which goes beyond what is mentioned, okay, it still can be ratified by the shareholders. But in case of a memorandum of association, if an act is done which goes beyond the MOA, it is ultra vires. It cannot be ratified, even if there is a unanimous vote of all the shareholders. Okay, so these are the basic points of differences. Now moving on to our second topic for the day, which talks about doctrine of ultra vires. We have already spoken about this while discussing the memorandum of association, the articles of association, but still we'll just discuss this in detail. So ultra vires is a Latin term, okay? Ultra, which means beyond, and vires means the powers, okay? So ultra vires is essentially an act that goes beyond, okay? So any activity that is contrary or in excess of the scope of activity of the Companies Act, the memorandum of association of the company, or the articles will be ultra vires. That is, it will be beyond the scope, okay? And all the actions that are beyond the scope are naturally going to be void, okay? So ultra vires the Companies Act. That is the first thing that we are going to discuss. Now, the power of the company is derived from the law governing it. We are all on the same page on that, right? Now, Section 6 of the Act also specifically says that anything that is mentioned in the Memorandum of Association or the Articles of Association, okay, that is contrary to any of the provisions of the Act are going to be void, okay? They are not going to surpass or superpass the Act, okay? They are going to be void. Now, any act done to the contrary or in excess of the scope of the activity of the companies will be ultra vires the Companies Act. Okay, such act will be void and cannot be ratified even if there is a unanimous resolution of the shareholders. Okay, this is what we have discussed. So, if an action that is undertaken by the directors of the company that is beyond the Companies Act, even if it is, say, in consonance with the memorandum of association, still it is going to be void, okay? And it cannot be ratified in case that happens. So here are a few examples. These are very general, but still we'll just discuss them quickly. If a board member is appointed or removed without, the statute, without following the process that is mentioned in the Act, it cannot hold good, okay? So the appointment or removal will not be on the legal grounds and it will not be admissible, okay? Payment of dividend out of the capital, okay? Or reduction of share capital, okay, of the company without complying with the legal formalities cannot stand good, okay? Now, it also declares that the provisions contained in the MOA or the articles, okay, or an agreement are void if they are in contrast to the Companies Act. Simple enough. If you have any doubts, we'll be taking those in towards the end of the session if time permits. So we'll just quickly move on to the next topic now, which talks about ultra vires, the MOA, the Memorandum of Association. Now, what is the Memorandum of Association? A Memorandum of Association is something that we've discussed, right? It is a constitution document. It outlines the scope of the company beyond which the company cannot act, right? So what happens if the company does something that goes beyond its object clause, okay, or beyond the Memorandum of Association? That will be construed to be ultra vires, right? It is outside the purview of the Memorandum of Association. It is outside the scope that has been defined while incorporating a company, and therefore it will be void. Okay. Now, in case of company, okay, whatever is not stated in the MOA as an object is prohibited. Okay. So this is essentially the doctrine of ultra vires. So while we were defining the Memorandum of Association also, we were talking about particular acts beyond which the company cannot go, right? So this is essentially the doctrine of ultra vires. So neither the company nor the contracting party can sue on it. Basically, if something has been transacted, the company has transacted with a third party, which is in contrast or in contravention or beyond the powers of the company that are mentioned in the Memorandum of Association, they cannot be ratified or they will not hold good. Okay, and they will be void. Now, moving on to ultra vires of the Articles of Association. Now, Articles of Association, as we've discussed, that Memorandum of Association supersedes the Articles of Association. But even if Articles of Association essentially lay out the procedure, right? So what will happen if the company does an act that is in consonance with the Memorandum of Association? It is permitted by the MOA, right? But you're not following the proper sequence that is mentioned, or the proper procedure that is mentioned in the Articles of Association. Okay, what will happen in that case? In that case also, the action will be void, but there will be a way in which it can be ratified. Okay, so if it is within the purview of the MOA but outside the purview of the AOA or in contravention to the AOA, then in that case it will be ratified. Okay, so in a general meeting, the company may alter its articles by a special resolution and ratify the unauthorized acts that have happened. Okay, moving on to the next topic that talks about lifting of the corporate wheel. Now, this is a topic that is closely associated with the feature of the company, right? Now, we've not discussed that, but it is very general. When we talk about a company, we know that it is a separate entity. It is a separate person altogether, right? It has its own existence, okay? It is different from the shareholders and the directors, right? It has its separate status. So, lifting of the corporate wheel essentially states that where a fraudulent or a dishonest use has been made of a legal entity, then the individuals concerned will not be allowed to take shelter behind the corporate personality, right? If the shareholders or if the directors are doing something that is not legal, okay, that is fraudulent, that has been done with an intention to be fraud, or it's dishonest essentially, at that point of time you cannot say that the company is doing something, right? Because at the end of the day, the shareholders, okay, are the members of the company, and the directors are the ones who are managing the operations of the company. So if they are acting dishonestly, then the courts will break the corporate share. Okay, they will break this separate status that has been granted to the company. It will pierce essentially the corporate personality, like it will essentially pierce the corporate wheel that has been crafted, and they will punish the actual offenders who have acted dishonestly, okay, or fraudulently, right? So this is what essentially the doctrine of lifting off the corporate wheel essentially means. Okay, the court will look behind the corporate entity and it will take action as though no entity separate from the members existed. Okay, and make members or controlling persons liable for the debts, obligations of the company. Okay, now these are two case laws which I came across. These are quite general. Okay, so from an exam perspective, if you don't remember the names, you can just write these as examples. Okay, so the first one talks about when the corporate wheel is lifted, when defense proceedings such as for evasion of tax, okay, an entity relies on its corporate personality as a shield to cover its wrongdoings. Okay, now even though a company has a separate status, okay, if the directors who are managing the company or if the shareholders also assent to it, okay, are evading taxes, right, in that case the corporate wheel will be lifted. Okay, and the offenders, like the ones who have acted dishonestly, would be punished. Okay, so this was the first case. The second case essentially talks about, now because this doctrine exists, lifting of corporate wheel exists, can a shareholder ask the courts to lift this corporate wheel for their own gains and purpose? Okay. So for example, in this case, what essentially happened was an individual, okay, a shareholder had uh, see, so a premises of a shop were allotted on a license to an individual licensee. Okay, she was an individual licensee and she had gotten this license. Okay, now she has set up a wholly owned private company, okay, and transferred the premises to that company without the government consent. Now the premises where she had obtained an individual license was transferred from individual to the private company because she was the sole owner of that company. Okay, and what essentially was asked of the courts was that because she was the shareholder of the private company, okay, and she was the individual in whose name the license was issued, she was essentially saying that uh, it it should be allowed, like it is legal, it is still legal. However, that is not the case. Okay, shareholders cannot ask for lifting of the corporate wheel for their purposes. It is only lifted in case a wrong, in case someone in the company has acted dishonestly, okay, or has acted in a fraudulent manner. A an individual or a shareholder cannot ask the court to pierce through the corporate wheel for their own gains. Okay, so in this case also, it was rejected. The contention was rejected by the court. She could not remove the illegality by saying that she and her company were virtually the same person. Okay, uh, so this concept of corporate wheel is also statutorily recognized. Okay, so the Companies Act itself contains some provisions, okay, which lift the corporate wheel to in case there are some wrongdoings and there are punishments for uh, the wrongdoers essentially. Okay, so section 7.7, for example, punishment for incorporation by furnishing false information. So at the time of incorporating a company, if the promoters of the company, furnish some wrongful information, then in that case, they would be punished. And, this is essentially, even though a separate company now exists, the people who have incorporated the company dishonestly, fraudulently will be punished. So this is one. The second section talks about 251(1), which deals with the liability for making fraudulent application for removal of name of the company from the registrar of companies. Okay, so And the punishment provision is also mentioned. Section 339 deals with the liability for fraudulent conduct of business during the course of winding up. So in case of winding up, also, if there is any fraudulent or dishonest business that is transacted by the persons, they will be punished, right? So these are few provisions that essentially also recognize the concept of lifting of the corporate veil, okay, wherein the separate status of the company is not recognized and the real wrongdoers are punished, right? So this talks about the statutory recognition. Moving on to the difference between the directors and the shareholders. Okay, now logically speaking, when we first think about these two roles, do we think there is a difference? Most of the times, when a layman talks about a company, right, the shareholders and the directors, a proper distinction is not drawn while we talk about them. But ideally, there is a huge difference between the two. The shareholders are the members of the company. They are also the real owners, okay, that own the equity shares of the company, that actually own the company, okay. But directors are only individuals who are elected to act as representatives, and uh, they implement policies, decisions, they act in the best interests of the shareholders, and they carry out the day-to-day functions. The shareholders are not essentially involved in the day-to-day activities of the company. The directors are involved in the day-to-day activities of the company, right? So this is the main point of difference between the two. We are also looking at their appointment, their roles, and a few other points. So the first shareholders, okay, the subscribers to the Memorandum of Association, the AOA of the company. So these are actually the subscribers, right? They are okay. So a director, now a first director. Who is a first director? Who nominates a director? Right? Initially, when the company is incorporated, the promoters, okay, nominate the director, and these directors are also mentioned in the AOA, which is subject to any approval if at all required. So they, get ratified by a board resolution or something once the company starts operating. Okay, so these are the first directors that are usually appointed by the promoters. Okay, but subsequent appointments happen through the board of directors in accordance with the specific process that has been mentioned in the act. Okay, so there is a proper procedure through which the directors are then appointed. So this is the appointment bit, the difference between the two. Okay, now the roles. As discussed previously, the shareholders are the owners or the members of the company, whereas the directors are the managers. Now, who can be a shareholder, right? So in case of a shareholder, an individual person, okay, an entity, a limited liability partnership, a firm, okay, a company, a society, trust, Section 8 company, artificial judicial person, anyone can become a shareholder, okay. But in case of a director, only individuals have the authority to act as a director, okay. This is the main difference between the two. Now, decision powers and attached responsibilities. Now, obviously, because the shareholders are not engaged in the day-to-day management of the company, the day-to-day functioning is handled by the directors, okay, and they are responsible for ensuring all the compliances are met, and the company is functioning in accordance with the AOA and the MOA of the company. Okay, shareholders are involved only in case there is anything important, like if there is any important matter where their approval becomes mandatory. There are certain instances which are mentioned in the act which require specific assent of the shareholders. So in that case, they are involved in the operations. Okay. Declaration of dividends in case of alteration of MOA, AOA, that is when they come into picture, but they are not involved in the day-to-day operations. Moving on. So minimum member requirements are also different. These are also mentioned in the Companies Act. In case of liability of the uh, members as in the shareholders, okay, they're primarily protected, okay, to till the unpaid debt, okay, till the, say for example, if a company is limited by shares, to, so they are liable only towards their unpaid capital, okay. So that is the extent of their liability, okay. In case of directors, the liability arises if they breach their fiduciary duty, okay, if they breach the trust that has been put, that, you know, that has been entrusted to them, okay. If they act ultra vires the articles or the memorandum of association, then in that case, uh, you know, they will be liable for negligence, okay. So this is the difference. Then the removal. Now, can removal or transfer. Now, in case of shareholders, the shareholders cannot be removed, right? A company, a person who owns the company, he essentially cannot be removed. That is actually, that may not entirely be true because there are ancillary contracts, which we are not going to discuss at this moment. But in case there is a call put arrangement, say, between the shareholders itself, right, those are the instances wherein, you know, you might have a right and an obligation to sell, etc., etc., but in an ordinary instance the shareholders cannot be removed, okay. They are, though they are free to transfer their shares, okay, they cannot be forced to exit, but they are free to transfer their shares subject to the procedure that has been prescribed, okay. But directors, the directors can be removed, okay. The procedure for removing a director is mentioned in the Companies Act, okay. So how they can be removed, there is a proper provision for that in the Companies Act, okay. The directors can also, may also be disqualified on certain grounds, okay. So these are usually very general grounds in case of insolvency, in case of, you know, conviction of any offense, you know, that is against the morals or the decency. Then that case the directors are also disqualified, okay. So they can be removed in accordance with the process that has been mentioned. Now, remuneration, the shareholders are entitled to dividend, okay. That is their form of uh, remuneration, you can say, okay. It is as per the company's policies, it is mentioned in the AOA, and, you know, how to declare a dividend is also something that is mentioned in the articles, okay. Now, remuneration for the directors. Now, this is something that is different than, you know, that of the shareholders. The directors are not entitled to any dividend. Okay, they are entitled to a fixed remuneration or a salary that may be agreed between them. Okay, but this is also, there is a restriction also prescribed under the act, so it has to be within those limits. Okay, the directors are offered their remuneration within those limits. Okay, moving on to the next topic, which talks about the duties and responsibilities of a director. Now, we've discussed the difference between the shareholder and the director, right? So, a director is responsible for the day to day operations of the company, right? So, the duties as defined in section 166 of the Act, okay? We are quickly going to discuss these. These are quite self explanatory, okay? So, the first, you can say, a duty to act as per the articles of the company, okay. So as discussed, the constitution documents, the MOA and the AOA talks about how to do a particular thing, right? So if a director is transacting anything, any matter, any day-to-day activity, okay, for the company, it has to be as per the articles of the company, right? Otherwise, we know that it is going to be ultra vires and it is going to be void. So the first duty is to act as per the articles of the company. The second duty is to act in good faith. Okay, so a director has been entrusted with a fiduciary duty. Okay, to act in good faith. He or she is trusted by the shareholders to manage the affairs of the company, and hence is required to act in good faith. Now, what happens if they do not act in good faith? what happens if the directors are evading taxes? Okay, we know that, right? We've just studied lifting of the corporate wheel. So if they do not act in good faith, okay, if they do anything that is dishonest or fraudulent, okay, the corporate wheel will be lifted and they will be punished. Okay, so they have to act in good faith. Okay, duty to exercise due care. Okay, so while performing any act, they have to exercise reasonable caution and they have to take due care. Now, this is quite subjective. Okay, it is open to court's interpretation, but due care can be construed in the sense that reasonable care, a reasonable person, if a reasonable person could figure out that a particular transaction would be detrimental to the interests of the company, then in that case, the directors cannot go forward with that particular act. So that is due care. Okay, duty to avoid conflict of interest. Okay, now this is an interesting topic. Conflict of interest. What happens if a director of a company has a stake in some other company also? Okay, and a business is being transacted with the company he is a director in and he has an interest in. Okay, and it is not at an arm's length price, or something is not uh, above the table. Okay, so if say for example there is a contract between A and B, okay, and say Mr. Ram, okay, has an interest in B company and is a director of A company, okay, and the particular transaction is being effected, right, where A is purchasing goods from B, okay, but the current market price of those particular goods are something else, okay, but they are being sold at a higher price, okay. So this is actually wrong, okay, but because the person would be in like would be benefiting from this particular transaction, right, the director would be benefiting from the transaction, this would be construed as a conflict of interest and it has to be avoided. Okay, so if any director in course of business comes to know that he has a conflict of interest in a particular situation, he has to put forth his point, or he has to disclose that conflict of interest to the board of directors. Okay, and so what usually happens is when a voting occurs, okay, when a resolution is passed by the board for any such instance where there is a conflict of interest of one director, he is not allowed to vote, so his vote is not casted. Okay, so this is a duty to avoid conflict of interest. If there is a conflict of interest, a director is supposed to disclose it to the board. Okay, now a duty to make undue gain. Okay, so the example that we gave, okay, was quite similar to this also. So a director cannot act for his own gains. He has to think about what is the best possible situation for the company. Okay, so he has a duty not to make any undue gain. Okay, duty not to assign his office. Okay, so basically he cannot delegate the powers he has to someone else. He cannot assign his office to someone else. Moving on, if the director does not follow or fulfill any of the duties that are mentioned, okay, if he contravenes any of his duties, what will happen? The director will be punished. Okay, so a director will be punishable with a fine which will not be less than 1 lakh rupees and which may extend to 5 lakh rupees. So the directors have to be very careful when they are acting for the company. Okay. Appointing and removing directors. Okay, now we just spoke about the duties and responsibilities of a director, but we also should understand how to appoint and remove directors. So when I used to appear for the exams, I often found that the best way to remember detailed answers or lengthy answers was through flow diagrams. Okay, so this is one such instance where we can actually refer to appointment of directors. So appointment of directors can be either the first directors that are through the who have subscribed to the memorandum. That is one way. ठीक है. Second is by the way of general meeting. Okay. Third is by the way of board of directors. Okay. Small shareholders, or by the tribunal. The tribunal also can make an appointment. We will quickly delve into a few detailed points in the next slides. So it is also important to understand the minimum number of directors that are required to be appointed. So in case of a public company, it is 3. In case of a private company, it is 2. One-person company has to be 1 because, as the name suggests, it's a one-person company. And the maximum number of directors is 15. Okay, without any special resolution. If more than 15 are to be appointed, then a special resolution is required. Now, appointment process. Now, first directors, as we've seen in the diagram, first directors are the ones who subscribe, okay, who are listed in the MOA or the AOA of the company. Okay, those are the first directors. Now, then you can appoint the members, okay, on the basis of the votes, okay, in a general meeting. So that is appointment at a general meeting. Now, reappointment of retiring directors. Directors who retire by rotation, okay, can be reappointed. There is a procedure that is mentioned in that, and the reappointment is done on that basis. Okay, regularization of additional directors. Now, directors appointed by the board as additional directors may need regularization at the next annual general meeting. Okay, so that has to be complied with. Now, there are a few mandatory requirements while appointing a director. Okay, nowadays, a company, like a director of a company, has to have a separate DIN. Okay, it is called as the director identification number. Okay, it is essential for all directors and has to be obtained prior to the appointment. Okay, now eligibility criteria. There are certain disqualifications. We've discussed this. In case of bankruptcy, in case the person becomes insolvent, okay, in case of criminal convictions, or in case there is a default in filing returns, etc. These are the disqualification criteria. A deposit requirement. A proposed director must pay a deposit of 1 lakh to be refunded upon election achieving a specified vote percentage. Okay, so this is also one of the mandatory requirements that has been introduced. Now, a board meeting, appointment procedure. When we say a director can be appointed by a board meeting, okay, now we all know the basics of a board meeting, right? A board meeting has to be properly convened. Okay, so for that, a notice has to be issued to all directors 7 days in advance. A proper notice along with the agenda and the purpose has to be circulated. Okay, it has to be issued to all the directors. The agenda, the items, okay, have to be mentioned in that notice, right? And including the proposed appointment. Okay, then the resolution is passed. Okay, and the appointment is essentially recommended to the members. Then the appointment is recommended to the members of the company. Okay, now consent and declaration. Now, the proposed declaration, director also submits a form as a consent to act as a director. Okay, so this essentially talks about the same thing, that you have to obtain a DIN, and a specific requirement of DSC and documents that are needed for making the DIN application have been outlined in this slide. We'll move on quickly to general meetings. Now, this is a general meeting. Okay, minimum 21 days clear notice is mandatory. Okay, it can be sent via hand, post, or electronic means. Okay, now in order to conduct a meeting, it is important to ensure a quorum is present, if a proper quorum is present or not. If it is not present, then a meeting will not be construed to be a validly convened meeting. Okay, then you have to pass resolutions for the appointment or reappointment of directors. Okay, and that's how the proceedings are usually done. You have to document each meeting by preparing the minutes thereof. Now, post-appointment requirements. Okay, post-appointment actions. There are certain actions that are required after the appointment of directors also. There are certain filings that are to be made. Okay, so these are the filings that are to be made. Form DIR 12 has to be filed with the ROC. It has to be submitted within 30 days of the appointment. Okay, it includes the consent and declaration that we have discussed earlier from the director, which also has to be submitted. Okay, we have to update registers of directors and key managerial persons. Okay, document interests of directors in form, okay, MDP 4, and compliance with other acts. Say, for example, if it the company has to be registered with the Shops and Establishment Act, and you have to disclose the names of the directors. So all of that has to also be complied with. Okay, that was about the appointment of directors. Now we talk about removal of directors. Okay, once appointed, a director can be removed. We have discussed this in the distinction wala portion that we have covered, right? Now, removal of directors. Under section 169 of the Act, a company may, by an ordinary resolution, remove a director before the expiry of the period or his office. Okay. Now, not considering anything, okay, that is contained in the articles of a company or any agreement with the director is concerned. This is regardless, okay. But what happens if a director is appointed by the tribunal? Okay, then he cannot be removed itna easily. Okay, if the director is appointed by a tribunal, there is a separate there's a special resolution that needs to be passed. There is, you have to go through the tribunal in that particular instance. But if it is a normal director that has been appointed, or a simple ordinary resolution to remove a director shall suffice. Okay, that is the first point. The second point is that an independent director reappointed for the second term, okay, can be removed by the company only by passing a special resolution. Okay, and after, in any case, okay, a director who is being removed has to be given a reasonable opportunity to be heard. Okay, he has to, like, the reasons for his removal and his justification has to be heard in the meeting before he is removed. That is a prerequisite. Okay, the provision relating to the removal shall not apply where the company has availed itself not less than 2/3 of the total number of directors. Okay, so you cannot remove any more directors before you appoint if the minimum requirement of the directors is not being fulfilled. Okay, now procedure for removal of director. Okay, the procedure for removal of director is, as we've discussed previously, it is by special notice. Okay, a member has to submit a special notice proposing an ordinary resolution for removal of director. Okay, the director who is being removed has to be notified, right? Then you call a meeting. How do you call a meeting? You share the agenda and the notice of the meeting, you circulate that. Okay, then you convene, okay, a meeting, and you transact the removal of directors. Now, after the director has been heard, after the director gets sufficient time to defend himself, okay, only then a director can be removed, right? Moving on, we will deal with difference between managing and a whole-time director. Okay, we've discussed appointing directors, removing directors, we've discussed duties and responsibilities of a director. Now we are moving towards the types of the directors: managing director or a whole-time director. Okay, now managing director, as you know, the word itself signifies, is the one who manages the company. Okay, who looks after the overall management of the company. He's typically a top level executive of the company. Okay, whereas a whole-time director, on the other hand, is a member of the company's board of directors who is also a full-time employee of the company. That person is a whole-time director. Okay, a managing director has the authority to make decisions on behalf of the company, whereas the whole-time director is responsible for providing advice and guidance. So a whole-time director is in his advisory capacity, whereas the managing director has authority to make decisions or transact matters that he deems to be in the best interests of the company. Okay. A managing director is usually appointed by the board of directors, while the whole-time director is appointed by the shareholders. Okay. So a managing director, you can say, is the head of the board of directors. Okay. So he is appointed by the board. But a whole-time director is usually appointed by the shareholders of the company for having an advisory role and an oversight on the transactions or the matters that are being transacted by the company. Okay. A managing director typically has a high level of authority and autonomy compared to the whole-time director that we've seen. And the role of the managing director often includes strategic planning, okay, while the whole-time director typically includes oversight and governance, right? So these are the points of major distinctions between the managing and the whole-time director. Okay. Moving on to conditions of appointment. Okay. Now, a managing director and a whole-time director are also, there are a few conditions that have been imposed under the Act. Okay. A company cannot appoint or employ at the same time a managing director and the whole-time director. Okay. And a manager who is a whole-time director. So they cannot appoint the same person. Okay. A company cannot reappoint any person as a managing director or a whole-time director or a manager for a term exceeding 5 years at a time. Okay. So if the term exceeds 5 years, they cannot reappoint the same person. No reappointment shall be made earlier than 1 year. So if the term is, say, of 5 years, okay, reappointment before the expiry of his term or appointment of someone else in his place before the expiry of his term, 1 year before the expiry of his term, cannot be made. Okay. The minimum age for appointment of these positions is 21 years, and the normal retirement age is 70 years. Okay. So if a person has to be appointed as a managing director or a whole-time director, he has to be more than 21 years of age. And he has to retire if he is more than 70 years of age. Okay. If you're saying that a person has to be appointed as a managing director or a whole-time director who has attained the age of 70, who exceeds the age of 70, then in that case it is possible, but you have to pass a special resolution for the same. Okay. So these are the conditions of appointment of a managing director and a whole-time director. Finally, we are moving on to the role of auditors. Okay. Now, auditors, this is essentially covered in Section 143 of the Companies Act. Now, we all know what a role of an auditor is, right? When we say an auditor, we directly think about the financial statements. Okay. So it is as simple as that. So an auditor is essentially a person who scrutinizes or audits the financial statements of the company. Okay. So for that very purpose, the auditor has to have access to the necessary information and documents, right? So the directors and the officers of the company are responsible to furnish such information to the auditor. Okay. And they have, like, in case the auditor has a few questions or queries, okay, if he has some questions, the directors and the officers are responsible to address those questions. Okay. Now he can inquire about the following matters. This is mentioned in the provision. It generally talks about when loans and advances are made. Okay. Whether it has been properly secured, whether the terms they have made are prejudicial to the interests of the company, its members, okay, if they are proper, in line. So he'll just audit through all the transactions, all the major transactions that the company has transacted. Okay. If the accounting has been properly done or not is also something that the auditor is responsible for. So if the loans and advances made by the company have been shown as deposits or not, this is also something that he'll scrutinize. Okay, whether personal expenses have been charged to revenue account, right? This is also something that, the auditor would be responsible for. Now, after auditing the financial statements and the books of accounts, the auditor will have to prepare a report, right? He'll have to prepare a report to submit it to the members of the company. Okay, whatever he has examined, okay, whatever his comments are, would be mentioned in the report. Okay, whether he has sought and obtained all the necessary information and explanation from the directors, or has there been some concealment, or if he has not been provided with the requisite documents that he had requested, all those things would be mentioned in the report. Whether proper books of accounts have been kept, right? His opinion of, the financial accounts, right? All this would be mentioned in the report. Okay. Secondly, audit report of a government company. Now, in case it is a government company, the appointment of an auditor is not that easy, because the auditor is then appointed by the CAG, right? So, such an auditor has to act in accordance with the directions that are given to him. So, for a government company, when an auditor submits a report, right, the CAG also has an authority within 60 days to revisit the audit that was conducted by such auditor and prepare a supplemental audit if he has any other comments on that, right? He has 60 days to conduct a supplemental audit. The CAG has that authority. Okay, and yes, so this is the difference. So private companies के लिए audit requirements are a little less stringent, but for government companies, the audit requirements are quite stringent. Okay, the auditing standards. Okay, now every auditor will definitely have to comply with certain auditing standards that are placed by the central government, okay, or the National Financial Reporting Authority, right? So based on that, the auditors will audit the financial statements of the company. Okay, the government may also notify the auditors. Report shall include statements on such matters as may be notified. Any additional matters that the government wishes to include in the audit reports moving forward, they can notify the same to the auditors. Okay, now while conducting an audit, okay, and while preparing a report, right, if the auditor comes across any discrepancies, okay, if the auditor finds any irregularities in the financial statements of the company, then the auditor of the company is required to report on the same, right? So if an auditor of a company, in the course of the performance of his duties as an auditor, has a reason to believe that an offense involving fraud is being or has been committed against the company by the officers or the employees of the company, he shall immediately report the matter to the central government within such time and in such manner as may be prescribed. So he is legally liable to report any fraud, okay, that has been committed against the company by the officers or the employees, okay, in the manner that is prescribed. So I think that is about it. We have covered almost 8 questions today. So I think if anyone has any doubts, or if they want me to discuss any of these questions again, they can just let me know.
Nikita, a participant is asking, can you guide on independent directors?
Sure. So, independent director is essentially, so he is, like the word itself suggests, right? Okay, no problem. So he does not have any relationship with the board of directors, okay, material relationship with the company, and is neither a part of the executive team or the day-to-day operations of the company, right? So an independent director is a member of he is still a member of the board of directors, but he does not have a relationship with the company or the board. Okay, is not a part of the company's executive team, okay, or the day-to-day operations of the company, right? So that is usually a separate process through which you can appoint an independent director, right? But that person is not engaged, in the day-to-day operations of the company. So like a managing director, right, who is the head of the board, who is the head of the board and is responsible for the day-to-day operations of the company, an independent director is not so.
Okay. Nikita, if the paid up capital is reduced, then which was previously paid. Paid up capital is reduced, then what happens to the stamp duty that was previously paid? Will that be refunded?
uh, okay, so if I'm sure, I think we'll have to examine the stamp act, but if the paid up capital is reduced, in that case, I do not see any provisions that guarantee a refund of the stamp duty that has been paid. But we'll still have to examine the provisions of the stamp act for that matter, because see, the stamp duty is paid for the document that has already been registered, right? If you're altering the document, right, there has to be a change in the initial document that has been prepared, right? It is essentially like you're amending a particular agreement or something like that, right? So a refund of sorts is not, I think, tenable, but we'll still have to examine this a bit further.
Okay. What is the difference between an independent director and a non-executive director?
Okay. See, a non-executive director, uh, an independent director is someone who does not have a, relationship with the board, and similar, like, so these are basically same, what do you say? These are synonyms, basically. So an independent director is a non-executive director of a company only, right? Who helps the company in improving its corporate credibility. It's not he or she is not a part of the regular operations of a company. He does not have any kind of a relationship with the company, but they are only nominated to adhere to the particular standards or the objectives. Okay, so independent directors should not be, they are not the managing or the whole-time directors, right? So they are not essentially involved in the day-to-day operations. So an independent director is a non-executive director only.
So, Nikita, I think we're done with the queries. And before we close, any tips for the participants so that they can score well? Any preparatory tips?
Because Companies Act is such a vast, it has a vast syllabus, okay, and it can be a little tedious to cover all the provisions of the Companies Act. So you can focus on the important questions and refer to the Bare Act more than the reference books, I would suggest, because even though it is tedious, right? A Bare Act will essentially update you on the latest provisions that are there, right? That are available. And you can, essentially study and score a lot better if you understand the provisions of the Bare Act. So I would suggest, like, while studying, you can refer to, additional books, or the notes that you have prepared, but refer them in consonance with the Bare Act, because I think that will help you a lot. Other than that, while appearing for Mumbai University exams, you should definitely be thorough with the questions that have come in the past papers, right? Because majority of the times these questions do repeat, so you would definitely be in a better position to answer the questions.
Okay, Nikita, thank you so much for elaborately explaining all the questions. And this was your very first time. So, again, I thank you for the efforts that you've taken and hope to see you soon. And hope our timings match and we can do a part two for this. So, thank you,
Definitely,
Nikita.
definitely. Thank you so much.